Hear ye, hear ye, hear ye. The Court of Appeals for the 14th District of Texas is now in session pursuant to adjournment. God save the Constitution and this honorable court.
Thank you. Good afternoon, everybody, and welcome to the 14th Court of Appeals. We have two arguments today scheduled. Just a quick note, I'll be presiding over today's argument, though ordinarily Justice Christopher would, as she is the senior justice on the panel, but she is traveling, and in the event she is disconnected from our argument, Justice Hassan and I will press on, and Justice Christopher will watch the arguments at a later date, and we'll be participating in the case. First, let's call the docket. I just want to make sure, well, I guess I see everybody's here. So in the first case, we have Sanchez versus Striever. And my understanding is the appellant has reserved 2 minutes for rebuttal. Is that correct?
Yes.
Okay, and in the second case, Hughes and others versus Dykeman and others. And I understand the appellant has reserved 3 minutes. Is that correct?
Yes, Your Honor.
Okay, well, let's go ahead and hear argument from the appellant in the first case, Sanchez versus Striever.
Okay, the starting point in this argument is the order, because there's specific findings in the order. And so the key finding, and I'll read it here, the act of pouring water over Mr. Sanchez constitutes protected speech. And then from there, the court said that the suit implicates First Amendment rights of the defendant, which is because of the first statement. And then the third key statement is Sanchez did not adduce any evidence of any injury whatsoever, even if he could allegedly recover mental anguish damages under the circumstances. That statement there is important because the court then dismisses and awards attorney fees based on Chapter 27, which is the SLAPP statute, and then Rule 91A. And so the first obvious question to me is whether or not pouring water on someone's head when they're making a speech is protected speech. And in the supplemental brief that I filed, I basically go through, first of all, I couldn't find any cases that actually dealt with somebody saying that they can lay hands on or physically assault somebody, and somehow that's protected speech. So if you go through virtually all First Amendment cases that I've ever looked at, and the ones that I focused on in the supplemental brief, all of them are based on the idea that you can say things up to a point. And the point is that whatever it's going to cause some sort of injury to individuals or society at large, then you can't do it. Okay, so
what evidence did Striever present that his pouring water on Sanchez was actually in connection with a protest of some sort or a First Amendment right? What evidence did he present?
What evidence did Mr. Striever or the
Striever?
Well, his evidence is the fact that my client was making a political speech in a forum for the public, and that he is a politician. And when he was making that speech, he was doing it in the capacity of a politician. And of course, the video, which shows the defendant actually pouring water in the middle of his speech. And so he also points to some discovery that was attached to the plaintiff's petition, where he says that the discovery somehow shows that the lawsuit was about stopping First Amendment speech. But the question is whether or not pouring water on somebody in any context is protected or not. And clearly this was a type of a situation where the First Amendment is really important, because it's all about exchanging of ideas in the context of politics, because that's what the First Amendment is all about, is encouraging citizens to get informed by exchanging ideas so we can make intelligent decisions at the ballot box or whatever it is as far as running the country. But that doesn't translate into you can, and clearly certain types of acts, symbolic speech. And if I pour water on somebody, that shows that I disagree with what they're saying at the time. And so clearly it has speech elements about it, but so does shooting somebody. And we just draw the line, or the First Amendment draws the line on physical contact with with some individual to not be protected speech. Um, and so the context was obviously something that the First Amendment is all about. But like throwing the brick at the politicians is a clear example. You can't do that. And then you got to look at the Texas statute on assault, which is assault by offensive conduct or contact is prohibited according to our legislature. It's a crime in itself, and so you just can't do that. Okay, so once you determine that this is not protected speech, then you don't get into the second aspect of this case, which is where the trial judge said that there was no evidence of mental anguish. Well, you don't even get to that under Chapter 27 because the burden shifts to the plaintiff to put on evidence to meet each one of their elements, only if it's not protected speech.
What are the elements of your cause of action?
Well, it would be basically you track the criminal statute. There's a couple of cases. One of them's a 14th court case. It's cited in one of the briefs. But the cause is physical contact. The person knows, the other will regard as offensive or provocative. That's straight out of the penal statute on assault by offensive contact. And then, of course, damages. And so the trial judge said that my side had not put on some testimony about what mental anguish there is. And of course, we all know that mental anguish is somewhat of a difficult burden you got to put something fairly strong on. But here you never even get to the requirement that my client actually put on his evidence of mental anguish, because under Chapter 27, the only way you actually do that, at first it's protected speech. So if it's protected speech, then my side has to put on some sort of affidavit or deposition testimony as to what the mental anguish was. But you never get to that because it's protected speech.
But the trial court, I'm sorry, counsel, the trial court did find it to be protected speech. So why did your side not put any evidence on of mental anguish damages? Because
they I can't hear you, Judge.
I'm sorry, that is the burden. The burden would shift if a court were to find that it was protected speech. And so in this case, the court did find that it was protected speech. And so why wouldn't your client put on any evidence of damages? Because
we disagree with the finding. If the finding's erroneous, then we don't have to put on evidence. Now, true, if the trial judge says that it is protected, and then we sit back and don't put on the evidence, we don't actually have to put on the evidence if we are so confident in our argument that we're going to win it on appeal, because we're not required to put it on at that point. And so if this court agrees with our position that it's not protected, then the court doesn't have the authority to dismiss, the trial court doesn't have authority to dismiss just because we didn't put on some evidence of mental anguish under Chapter 27.
Right, but if the court did agree if the court did not agree with you, just hypothetically,
right,
then what evidence would you have of the prima facie case below?
We didn't put any evidence of mental anguish on. So if this court disagrees with our legal premise about the First Amendment, that you'll say that it's protected speech, then we didn't put on evidence of mental anguish. So under Chapter 27, then you'd say, one, it's protected speech. Number two, Hootman's client didn't put on evidence of mental anguish, and therefore you'd affirm it. Now that actually takes you to the 91A dismissal. Okay, so 91A never ever does the plaintiff have to put on evidence of their mental anguish in a 91A challenge, because 91A specifically looks only and exclusively at the pleadings. And here the pleadings spell out the elements of assault by offensive contact. And then also states in it, I think it's on page 3 of the pleadings, that there's mental anguish. So that's all you look at. So the only scenario under these two types of motions where my client would have to put on evidence of mental anguish would be if this was First Amendment protected speech. So to me, it all comes back to that.
So the Supreme Court has said that the TCPA is even broader than the constitutional protections in some of its cases, that, you know, they're not coextensive. So, because it says in connection with your First Amendment rights.
Okay, I believe that those statements come from section 27.0013, which defines exercise of the term in the statute, exercise of the right of free speech. So that is defined quite broadly by the statute, but it still comes back to exercise of the right of free speech. And so it would be strange to me, of course, I could be wrong here, but if the statute somehow was different than the First Amendment, then we'd have a problem of whether or not the statute, okay, let's say that the statute is, I guess, more protective than the First Amendment. I actually don't know how that would write up, but it seems like you'd have a conflict between the First Amendment and the statute itself. Of course, there's the well-standing law that says that the state can provide more protection than the First Amendment. But under the statutory definition of exercise of a right of free speech, it says, quote, a communication made in connection with a matter of public concern. And so is dumping water on someone as they're speaking, is that a communication made in connection with the matter of public concern? I think under the statute itself, it's not. Because again, you come against all these concerns about speech that actually injures or interferes with someone's autonomy. And it's just the words of the statute just don't get you there on that. And then you have the slippery slope problem, which is, well, you can dump water on them. Well, how about a gallon of water? How about 10 gallons? How about a hose? You know, where do you draw the line in that scenario? But I really think it comes down to the actual statutory definition, which in this context is the same as the First Amendment problems that I discussed, you know, earlier in this argument and also in the brief. So I think it would be interesting to see how you could write up this particular scenario to say that.
Well, but were you required to put on the elements of assault in connection with this? I mean, you've pled it as an assault, but you didn't put on any evidence of the offensive nature of or that they knew or should have known of the offensive nature of the contact, correct?
Right. So I think the answer to that is a procedural one. It's whether or not, when does the plaintiff, my side, have to do that? They only have to do that once first the other side has crossed the bridge of exercise the right of free speech. And so if the dumping water on his head is an exercise of free speech, then it shifts to us to put on evidence of the elements of the cause of action. And so again, you don't, now assuming what Justice Hassan had thrown out there, that you all decide that it is protected speech, then no, we didn't put on any evidence other than the video itself. The video itself is in evidence, but as far as testament, okay, the trial judge's order said there's no evidence of mental anguish. Okay, so sticking to what the trial judge actually based its decision on, I think that we would have had to have put in some evidence on, you know, affidavit testimony about how strenuous it was on his mind on that, not the other elements, because that wasn't what the judge's ruling is based on.
But isn't our review de novo here?
Yeah, but I think you're stuck to the I think you're stuck to the words that the basis of the trial court's ruling. So I don't think your de novo is to review literally everything, because the court specifically limited its ruling, and also the statute, chapter 27, requires the judge to state its basis for the ruling. So, but even if you did go beyond the actual factual basis of what the judge said in its order, I still think you come back to this First Amendment issue. And then the interesting question that Justice Christopher raises is, somehow is the statute different than, does it give more protection than the First Amendment? But either way, you have to cross the bridge. You can't affirm by saying that my side didn't put on evidence, because you first have to say that it's First Amendment protected. And I see my time's up here.
All right, thank you, counsel. We'll hear from you on rebuttal. Thank you.
All right.
think I need to click on something here. Oh, there we are. Okay, thank you. I'm Steve Duble here for Steve Stryver. I think the facts are undisputed in this case. There's no dispute that Mr. Sanchez was giving a press conference having something to do with HISD. There was a group of protesters out there. My client was one of those protesters. You've seen the video probably.
Okay, but you say the facts are undisputed, but what facts, what evidence did you present?
Well, there's, I think, a number of videos and news reports that went in without objection, as I recall. And in the pleadings themselves, pardon?
It was just one video, I think, that was in the record, and it was presented by Mr. Sanchez's counsel. But under the TCPA, what can you rely on to make your preponderance of evidence for that first prong of the TCPA? Do you?
Well, I think Judge Christopher touched on it earlier, that the statute's much, much broader than this. I don't think you have to get to the issue of whether pouring water on someone is free speech. I think it can be under certain circumstances, but I don't think that's a threshold question here. All I have to do, and I think what we did do, is by preponderance of the evidence, we showed that my client was out there exercising his right of free association with the fellow protesters and his right of free speech.
Where did you do that?
Pardon?
Where in the record did you do that? Where did you show that your client was exercising his right to freedom of expression under the TCPA? Can you point us to a place in the record?
I think it's the pleadings, and I don't have the whole record printed out in front of me, so not off the top of my head, and I apologize, but I believe that I've met my burden. I'll have to go back and look and see, but I think the pleadings themselves, it's clear, this is clearly a frivolous lawsuit. Mr. Orlando Sanchez has no damages whatsoever. He's admitted it's only a civil assault claim for mental anguish damages. We all know that that's not a case. There's something going on here. I don't know what it is, but his pleadings are very telling. And when he asks for all my client's communications with the fellow protesters and all of the communications about how they came together and to do this protest and their communications after, it's undisputed that what he's trying to do implicates my client's free association and free speech rights. He's trying to squelch it. He's trying to shut it down by the filing of the lawsuit itself. So even if you don't get to pouring water being free speech, Mr. Sanchez's actions in filing a frivolous lawsuit when he has no claim for $1 million against my 21-year-old client is nothing. That's exactly what this statute was designed to stop.
Let me ask you a quick question. You say the lawsuit is frivolous, at least with respect to Rule 91A. And when we looked at the pleadings under 91A, do you agree that Mr. Sanchez pleaded a claim for assault? And if you do not agree, which elements are missing from the petition?
He technically pleaded a claim for civil assault. And if he had damages to be redressed, then there'd be a claim there, but he doesn't. And I'm not sure how this plays, but I did glance at the penal stat code this morning. And I know that it's the same definition of the penal code for assault as it is civil. And there's no bodily injury here. And they do define in the introductory section of the penal code bodily injury, and he didn't have it.
Yeah, I mean, and bodily injury would take this entirely out of the TCPA because there's an exception in the TCPA for cases that deal with bodily injury, but he didn't plead that. He pled assault by offensive contact. And so bodily injury isn't an element of this particular cause of action. Is that correct?
But he has to have damages to redress, and he has none.
But he did.
Is that a summary judgment issue?
I don't think so. I think this is exactly what this statute was designed to stop. A powerful politician who's got, a former Supreme Court justice on his team now. I don't know what this is about, but this is a frivolous lawsuit designed to shut down and squelch these protesters. And he's angry about it. I don't blame him. And, but that's what this whole lawsuit is about. And that's undisputed. And that's just on Mr. Sanchez's petition that's there. It's very clear that that's what his intention was.
Are you contending for 91A purposes that the lawsuit has no basis in law or no basis in fact, or both?
Given these facts, yes.
No
But,
basis in fact or law.
well, technically as a basis in law, but given these facts, no, there's no case here. It's completely frivolous.
But there is a video. And so you all know, I mean, you started this argument by saying you all know what the facts are. So the elements of the cause of action of assault, were they met?
Don't know. Are there cases out there where throwing water on somebody or a droplet? I mean, you've seen the video too, and my recollection is that Mr. Sanchez doesn't look scared. He doesn't. I mean, he looks annoyed. I don't blame him. I'd be annoyed, but he clearly didn't have any apprehension or fear evident in that video, and I don't think there's an assault here.
So the assault by offensive contact, again, though, one of the elements is not fear.
Correct. And they did point out the Waffle House case, and I can't remember the name of the other one here. But those were sexual harassment claims. At one point, I mean, if Beaver Cleaver walks on somebody's lawn and shoots a water gun on Mr. So-and-so, is that a civil assault case? I don't think so. This is a frivolous case. And then the other argument is under anti-SLAPP, we clearly met our burden of showing that.
Well, that all hinges on your belief that it was not an assault, correct? I mean, you do recognize that there are First Amendment cases that say assault is not a protected speech.
Well, are you talking about the frivolous lawsuit side or the anti-SLAPP?
Talking about the TCPA.
Okay. No, I'm not sure it does. I think, and we got into this in the oral argument with Judge Engelhardt, I recall. And I think if there's no damage resulting from it, if I flick a person on their shoulder, is that an assault? I mean, maybe technically. If I poke a person in a heated argument on their chest, is that an assault? Is it inappropriate? Maybe crossed a line, but is it a civil case? I don't think so.
So, I mean, we have a lot of protests going on now, like since the time this happened and now, I mean, we're in the middle of a time of lots of protests. And there are various kinds of assault that potentially could be brought, right? I mean, so if somebody is protesting for the freedom not to wear a mask during a pandemic, for instance, then is it an assault to breathe on somebody else? I mean, that's what you're asking us to do, is to make a distinction between one kind of assault that may not be that bad and another kind of assault.
But those facts aren't before you, but I see your point. And somewhere that, pardon?
This is a hypothetical.
I see your point, but the facts of this case is that this is frivolous. And what Mr. Sanchez did by filing this lawsuit against a 21-year-old kid or young man for $1 million, when he's basically admitted he has no damages and nothing to redress, that is a frivolous lawsuit. And without a doubt, it is trying to squelch my client's free speech rights. The lawsuit itself.
He can talk all he wants. He just can't assault someone. I mean, that is the issue, right? Was it an assault?
I suppose had he assaulted him and injured him, perhaps he could have been arrested. Perhaps he could have faced criminal charges like in any civil disobedience case. But no charges were filed here. There's also evidence in the record that, they chased down my client and held him to the ground. And yeah.
So are you advocating that criminal charges should have been filed instead of a civil lawsuit?
No, this is way blown out of proportion. Mr. Sanchez apparently got angry over this, but it's very clear, and he admits it in his discovery. All he wants to know is, who are all these protesters out there? What were y'all talking about? I want to have all the records. And what possible reason could that be for, other than to squelch my client's free speech rights and his free association rights?
That petition was superseded, though, wasn't it?
I believe there was an amended petition filed, but it's still evidence that that's what his intentions were. And why else file a lawsuit for $1 million when you have zero damages? And I mean, you've seen the video. There's no, under Texas law, there's no way this is a redressable action.
Counsel, you keep mentioning the right of association. Why is pouring water on someone's head an exercise of the right to associate?
It's not. But what is, and this goes to the discovery that was included in the petition. It's part of the petition. He asks for the cell phone records and the text messages between my client and fellow protesters. That's what he's asking for. It's very clear he is implicating my client's free association rights in this lawsuit. And that's what he's trying to do. The whole lawsuit is trying to squelch my client's constitutional rights.
The DCBA deals with what's in the petition, not what's in discovery. So how do we, you did not put on any proof that it was impacting your client's right of association.
Well, he put it in the petition. And I guess we get into a technical argument. If you put discovery in a petition, does that make it a pleading? I don't know. I doubt there's any law in it, but he voluntarily placed it in his petition and made it clear that that's what this whole lawsuit is all about. And what else could it be about?
When you say he placed it in his petition, are you meaning that he served it with his petition as is allowed under the rules?
Of his plea in his original petition, it's paragraph 11.
It was in the body. Okay, thank you.
It's actually in the body of the petition.
In his original petition, it was
Correct.
taken out of the amended petition.
Correct.
Yeah.
And I admit we'd be dealing with something different if Mr. Sanchez was injured, or if my client, God forbid, had poured acid or something like that on him. It's a whole different ballgame, but that's not what we have here.
So you'll agree, though, that the TCPA doesn't, it's not a bar to a lawsuit. Like it's a motion to dismiss if the plaintiff cannot make a prima facie case. And so if Mr. Sanchez had put forth evidence of his damages, what you're saying is that you would be okay with the case going forward, even though you believe that it was frivolous. Because if he put on evidence of his damages, even in the form of an affidavit, would that not be clear and convincing evidence under the TCPA?
I don't think so, but you might be right. But the fact is, he put on no evidence, and my reading of the statute is much broader. You can detach the whole water thing if you want, in my opinion, and just look at Mr. Sanchez's actions in filing the lawsuit. That was the violation of the TCPA. That's where he's getting into my client's free association and free speech rights. That's what this lawsuit's all about, is to silence protesters, to scare young protesters like that are out there doing this. There's no other purpose. I can't imagine what another purpose of this lawsuit would be. I can't think of one.
So if Mr. Sanchez had a viable claim for assault in this case, it would still be frivolous because his intentions were poor? Is that essentially your argument?
If Mr. Sanchez had a redressable injury, I think that's the distinction. That's where I would draw the line.
All right, any further questions or Anything else from you, counsel?
Thank you.
All right, thank you.
Let's see, we sign off.
Okay,
Are you more time? Sorry.
do you see me?
We
Okay.
can.
Yes, go ahead.
Okay, assault is never protected by the First Amendment. It's just never protected. And then as far as the statute, a communication is the key word in the definition, the statutory definition. Assault is not a communication under the statute. So to avoid the First Amendment, say the statute provides more protection than the First Amendment, you would have to hold that that assault is a communication under the statute, and it's just not as a matter of statutory interpretation.
It doesn't specifically say that assault is not a communication though, right?
Say that again?
So the statute doesn't specifically carve out assault as not a communication.
No, the statute speaks in general terms about what a communication is. A communication is made in connection with a matter of public concerns, is the language used. It doesn't categorize any sort of conduct. But to reach the conclusion that Justice Christopher was playing around with, you'd have to hold that assault is a communication, and it just doesn't fit under the language of the statute.
Other nonverbal actions have been held to be communications, though. Is that correct?
Sure, symbolic speech, burning a flag. You know, there's all kinds of symbolic, making a smirk in your face when someone's making an oral argument, for example. That's symbolic speech. But an assault is a whole different level because you actually injure somebody. And not to mention the legislature has passed a specific statute that we're suing under, saying that assault by offensive contact is prohibited. And so the legislature has spoken on that. Now, much of the arguments that my opponent was making are essentially jury arguments. He's saying there's not an assault, it's not an assault, it's not an assault. Those are all jury arguments that can. We're stuck to the actual form of the pleadings here when we're analyzing this. So under Chapter 27, you can't move for a Chapter 27 dismissal because there was no evidence of damages. You have to move that it was a communication that's protected, and then then that shifts the burden to us. So we never even get to having to put on evidence. And then he can go argue to the jury there wasn't an assault, but as far as dismissing this thing under either one of these two statutes, you can't do that. And then Justice Jewell was talking about fact versus law. Well, there's a basis in law because assault by offensive contact is a criminal and a civil cause of action. So that's in the pleadings, which Rule 91 requires you to look at. There's a basis in fact because some reasonable person could believe that the facts pleaded were an assault and he had mental anguish. All that begs the question of what the jury is going to be convinced by, assuming the plaintiff eventually puts on some evidence at summary judgment or trial at some point when he's required to actually marshal his evidence. So for all those reasons, the case should be reversed.
So just one last question. So you agree, though, that the TCPA specifically exempts claims of bodily injury. Is that correct?
I believe there's a provision in the statute that says that.
And I've heard you argue about assault and the bodily injury aspect, or assault being a harm to someone. So why did Mr. Sanchez allege bodily injury even in his pleading?
His pleadings, I have them right here. I highlighted the key portions. I believe the portion that matters is he says mental anguish.
Right.
I don't believe anywhere in there it says bodily injury. But that drives you back to the case law on civil assault by offensive contact. There's a 14th case. It's cited in one of the briefs. I don't have it handy, but it specifically says that is a cause of action, even though there's no physical harm because of the criminal statute. And again, that's not the type of motion we're dealing with here. See, he was arguing in his argument there that he gets to just move first if there's no evidence of damages. So you don't get to do that. You have to move under 27 that it's protected speech. Then that shifts the burden to us to do something to try to overcome the protected speech argument. And so you just can't be arguing the facts like we're here in front of a jury about all this, or on summary judgment, because we were never required to put on our factual case of damages or cause of action. You just look at the pleadings. So
All right, further questions from the court? All right, thank you, counsel. The case of Sanchez versus Streever is submitted
thank you.
for your argument. All right, counsel, can everyone hear me?
Yes.
Okay. All right, so we'll proceed with the next case, and we are ready to hear from counsel for the appellant.
May it please the court. Anna Mackin for the appellant, Secretary of State. With the court's permission, I reserved 3 minutes for rebuttal. Appellees in this case are libertarian candidates and their supporters, and they challenge Texas Election Code Section 141.041, which was part of 2019 legislation that made 2 key changes to third-party ballot access in Texas. First, it significantly lowered the threshold for a third party to obtain ballot access. And second, it required third-party candidates to submit the same filing fee or petition in lieu of filing fee that major party candidates already must submit before being placed on the ballot. The district court erred when it enjoined 141.041 as unconstitutional because it ignored decades of settled case law holding that the state has a significant interest in requiring candidates to show popular support before they are placed on the ballot, and that the state can further this interest by requiring candidates to submit a filing fee or petition in lieu thereof. The district court further erred in finding that the Secretary's advisory implementing Section 141.041 violates the election code itself. The advisory merely set a deadline for compliance with Section 141.041, which is silent as to any such deadline.
But let me ask you a question about that real quick, counsel. So the
Sure.
election code provision refers to a candidate who is nominated by convention instead of, let's say, a candidate who seeks to be nominated by convention. So doesn't that mean that the injunction is at least appropriate insofar as it concludes that the advisory violates the code provision?
No, Your Honor, I don't think that it is, because I think it's telling that the appellees have not cited any election code provision that draws a distinction between a candidate and a nominee. And in this case, since the statute doesn't specify at which time the requirement has to be satisfied, I just don't think it rises to the level of a direct conflict, as would be required to amount to a violation of the election code itself. Because the district court ignored settled precedent disposing of the appellee's constitutional claims and disregarded the election code's plain text, which forecloses their statutory claim, this court should reverse the temporary injunction order and render judgment dismissing this case. So turning to appellee's argument that Section 141.041 unconstitutionally burdens their political rights, Texas and federal courts apply the Anderson-Burdick balancing test in reviewing allegedly unconstitutional election laws. And under this test, they weigh the character and magnitude of the burden on constitutional rights against the state's interest in the rule, viewing the election framework in its totality. So walking through that balancing as to the state interest, the United States Supreme Court has squarely held that states have an undoubted right to require candidates to make a preliminary showing of substantial support in order to qualify for a place on the ballot. They held this in Monroe versus Socialist Workers Party, as well as a litany of other cases cited on pages 21 and 22 of our brief. And with respect to this interest in ensuring candidates have substantial support, the case law also tells us that one way candidates can show this support is through a filing fee. But the process of qualifying candidates for a place on the ballot cannot be constitutionally measured solely in dollars. So there needs to be a reasonable alternative to paying a filing fee. And one of those reasonable alternatives is allowing a candidate to submit a petition signed by their supporters to show that popular support. So by doing
what evidence did you put on to rebut the Libertarians' evidence that getting the petition signatures was too burdensome?
Your Honor, under Monroe versus Socialist Workers Party, the state is not required to put forth any evidence demonstrating a need to unclutter the ballot or limit the ballot to serious candidates, which is the word that both this court and the United States Supreme Court have used. Instead, the plaintiff who is asserting that a law imposes an unconstitutional burden has to show not that that particular plaintiff cannot satisfy the standard, which is at the very most what the evidence in the record shows, but instead, and this is the way the Supreme Court articulated the test in Bullock versus Carter, that a filing fee alternative is unreasonable only where a candidate can be precluded from seeking the nomination of their chosen party, no matter how broad or enthusiastic their popular support. So under this test, it's immaterial whether these plaintiffs can get the required signatures. The test instead is whether no candidate could comply regardless of how widely supported they are. And the record does not support that conclusion here. And after all, thinking about Anderson-Burdick as a balancing test where the election framework is viewed in totality, the appellees focus on this additional petition or filing fee requirement, but they completely ignore the fact that the ballot access threshold has been substantially reduced. So any additional burden of this new requirement for third-party candidates is sensible given the significantly reduced threshold for a third party in general to access the ballot. This court's jurisprudence emphasizes this result. The Reisner versus Harris County Republican Party case cited on pages 30 and 31 of our brief applied Anderson-Burdick in upholding the election code's requirement that Harris County Justice of the Peace candidates comply with one of two requirements: either submit a filing fee and nomination with 250 signatures, or submit a nominating petition with 500 signatures. This court held that that was not a significant burden on candidates, and it didn't interfere with any fundamental right because it applied to all candidates regardless of party. And in doing so, this court reiterated the state's undoubted interest in requiring this substantial showing at the outset and found that a petition or filing fee alternative was rationally related to the state's interest in, and I'm quoting here, preventing or discouraging unqualified or frivolous candidates from obtaining a place on the ballot.
Going back to the statutory construction question, the statute at issue talks about placement on the general election ballot. It doesn't talk about getting your name in front of a nominating convention. And that would only be one person who gets placed on the general election ballot, the person who was actually nominated. So how is this petition and filing requirement applied to candidates as opposed to the person who was actually nominated? It's a very different system.
Yes, Your Honor. Well, I think it's helpful to think about what applies to Republican and Democrat candidates. One of the threads of the appellee's argument is that Republican and Democrat candidates have to pay this filing fee or comply with the petition requirement before the primary election. And then they get to run in the primary election and they don't have to do anything else to run in the general. Well, in essence, that's exactly what is being applied here in the context of third parties. In order to be eligible for nomination at their convention, they have to comply with this same requirement at the same time during the process. And this actually ensures
Well,
that
I understand that's your argument, but how do you find support in the statute? The statute doesn't say that.
the statute does not expressly say that, no, Your Honor. But the two questions are whether this unduly burdens candidates, and under the case law just discussed, that argument is.
If it's not statutorily required, we know it unduly burdens a candidate, period. So it has to be statutorily required. You have to meet that burden first.
I'm not sure I'm understanding the question. I
If it's not statutorily required for the candidates, but it's only statutorily required for the candidate who has been nominated, you can't add requirements to the candidates.
Your Honor, I think that under Anderson Burdick balancing, in terms of ballot access requirements, I think the question is just whether it meets that Bullock versus Carter standard of making it impossible for a candidate to seek nomination, regardless of how broad or enthusiastic their popular support. And I think that's a different question from the statutory construction question of whether the election code is in fact violated by requiring candidates to comply with the filing fee or petition requirement at the threshold of the cycle. Because this application deadline, when the filing fee or petition must be satisfied, it sort of tees off an entire line of other dates and deadlines. For example, the dates of nominating conventions and primary elections, the deadline for the party to certify its nominees to the secretary, the timeline to replace candidates who die or are declared ineligible, the deadline for the secretary to actually certify a party's nominees to local officials for placement on the ballot. So by requiring third-party candidates to submit a filing fee or petition at the beginning of the process, just as the major party candidates must do, the Secretary's advisory is ensuring that Section 141.041 operates seamlessly in the context of the election code.
But the major parties are treated differently because their candidates are, first of all, chosen by primaries. And that's kind of the kickoff that you were talking about here. And also their filing fees are paid to their parties. Isn't that correct?
The filing fees, Your Honor, I think it depends on the office directly who the filing fee is submitted to, but the appellees haven't identified any authority for the notion that what a filing fee is used for has any bearing on whether it is unduly burdensome under Anderson Burdick. And in fact, the United States Supreme Court in American Party of Texas versus White has already spoken to the fact that it is not unconstitutional to require third parties to nominate via convention while major parties nominate by primary, because you're not saving the major party from anything that it doesn't already have to do. Just because they're not nominating at a convention, they still have to have a convention to promulgate a party platform and conduct other business. And the Fifth Circuit case, the Kirk case, also cited White and reiterated that result in the context of the election code.
All right, counsel, thank you. Any further questions?
I have one more, sorry. Do the Libertarians have to certify who their candidates are before the convention, before the Libertarian convention? Do they have to provide any information before then?
I do not believe so, Your Honor. But I would have to double check with my client. I'm not 100% sure.
Thank you.
Thank you.
All right, thank you, counsel. We'll hear from you in rebuttal.
May it please the court. For the first time in Texas history, maybe American history, Nominees of a party are required to do things to get on the general election ballot, not the primary ballot, but the general election ballot. And it is only third parties who are so required. Major parties don't have to do it. Independents don't, write-ins don't. Plaintiffs sued challenging the constitutionality of a portion of this new law. And also under the advisory, challenging the constitutionality and the legality of the advisory that the secretary put forward. Time is of the essence.
I have a threshold question for you.
Yes, Your Honor.
Are any of the appellees current candidates?
Yes, the nominating conventions have been held for county offices in March. And so now we have some nominees. All of
The ones who sued here, are any of the ones who sued here a candidate?
Yes, only 2 were not candidates. All the rest of the 11 were candidates, and now some of those have become nominees.
Yeah, that's my question. Have they actually been nominated at this point?
The state convention, all but the statewide candidates have been nominated. Although in our plaintiffs, there were 2 plaintiffs going up for the same nomination and only 1 got it. But the statewide convention has been postponed to till July. That's when statewide nominations would be made.
If no candidate is actually nominated by the convention, how do the candidates then have standing?
Well, some have, but they have standing as people who, as voters and as convention delegates and who want to vote for their nominate of their choice. And so they do now have a nomination standing. I could tell you which ones do, but probably 7 of the plaintiffs are now nominees. And standing has
If you
not
could
been
follow
found.
up, if you could follow up with that information for us, please.
I will do that. I will
Thank
do
you.
that. Time is of the essence in these 2 accelerated appeals of the temporary injunction against the secretary and county officials. On August 27th, the ballot must be certified. So we do have some time constraints here. This new law does have 2 parts and only one was challenged. And that is the one requiring filing fees or petitions. I'll talk about filing fees and not about petitions because the undisputed evidence is that petitions are not a reasonable alternative to fees. And it costs more, and that's why most people don't use them. But the other part is significant, and that was what was codified at 181.005C. And that, the status quo before this new law was that there were 3 parties on the ballot: Republicans, Democrats, and Libertarians. Greens had lost ballot status with no hopes of ever regaining it. But this new law resurrected the Greens, put them on the ballot retroactively. And so now we have 4 parties on the ballot. So but that part did nothing to help the Libertarians because they always had to earn their ballot status by hitting 5% in a statewide race repeatedly. So we got nothing, the Libertarians got nothing out of that except another competitor.
Is it your belief that the temporary injunction as written prevents the Secretary of State from collecting the fee or requiring the petitions at any time?
Yes, that is our position.
That the injunction as written.
As written, it does. Well, I'm not sure I'm understanding, but let me try to answer this. We think that it is unconstitutional on its face and as applied. We think that it is unconstitutional to burden, even in the slightest, any nominee of a party to be on the general election ballot. And that's because a general election is a core governmental function. It's one thing to charge major party candidates to be on the primary ballot, because that's a party function largely. Although $17 million of taxpayer money went to subsidize the primaries in 2018, the Libertarians nominate by convention, which they fund totally themselves. So there's no taxpayer money, no burden to the taxpayer on this process. So I'm not sure I answered your question, Your Honor. Let me know if I didn't.
My question is, the temporary injunction said you don't have to pay the fee by December 9th or at any time. So are you reading the temporary injunction essentially as a permanent injunction here? That even once you have your candidates believe that under the temporary injunction, they don't have to pay the fee or do the petitions?
That's right. The secretary is enjoined from refusing to certify because that's her function. But she's enjoined from refusing to certify on the grounds that a fee wasn't paid or a petition submitted for failing to comply with the new law. And the same thing for the local county.
And is your contention under the constitutionality of the code provision, your contention is that it is unconstitutional under the Texas Constitution only, correct?
Yeah, that's all we sued for under the Texas Constitution.
Okay.
And the specific provisions were, well, in Article 1, equal protection, due process, free speech, assembly, associational rights, and also under Section 3, no special laws.
Getting back to the differences between the major and minor party candidates. So anyone who is seeking the nomination of a major party has to pay the fee, and they have to do that before they even know if they're going to win the primary. So before they even know if they're going to be the candidate, all right? So why should a different process apply for a party who's seeking the nomination of a minor party?
Because the Republican primaries, the major party primaries are taxpayer funded, and they are applying to be on a primary ballot. The Libertarians are not applying to be on a primary ballot. So why should they have to comply with anything pre-nomination? There's nothing, no state interest in the Libertarian conventions. There's no taxpayer monies. They don't fund it. They don't control it. And so there is no reason for the Libertarians to be made to comply with what the others do, because they're not on a primary ballot. They don't burden the state at all. And the monies that they pay goes to their parties. But the monies Libertarians are required to pay goes to general funds. And that makes it a tax. When fines and fees go to the general funds, it's a tax. And to be on the general election ballot, it's akin to a poll tax. Now, the precise interest that the state puts forward is what the case law says you should evaluate and compare to the burden being caused. Here, we think that the precise test that was articulated by the secretary was, and this is general language, avoid confusion, deception, frustration of the democratic process as far as having an unrestrained ballot overcrowding. Our letter brief, which we filed yesterday, sent over the case, the Thurston case from the 8th Circuit Court of Appeals, and it tracks our case amazingly. That same interest was asserted, and the court found that there was no evidence of an unrestrained ballot. There, the Secretary of Arkansas did put forward evidence, but the court found it unpersuasive, and they examined it, and they said, under that law, no third party could make the ballot under the previous law. So the new law, which increased the requirements, so you can't justify that by ballot overcrowding. And here, if they're saying, well, we want to have don't want to have a crowded ballot. Well, you just passed a law which took us from 3 parties on the ballot to 4 parties on the ballot. So you're obviously not concerned about overcrowding. And the evidence, undisputed evidence, was that there is no overcrowding, that half of the major parties cannot fill half of their ballots. And in 2018, a voter going to a Harris County poll would see as many as 25% of the races on their ballot unopposed. So they had no choice at all. That's what they would have seen without Libertarians. But with Libertarians on the ballot, that cut it in half. So there is anything but overcrowding. We have lack of competition. We have lack of choices for voters in this, and that's not going to change. There's no threat the Thurston case also showed that you have to examine the assertion. You can't just take counsel's statement, ballot overcrowding, and without any evidence to support it, and with nothing in the legislature history to support that as the state interest, you can't just take it unexamined. The nomination has always been the ticket, your ticket to the general election ballot. And it's true now for the major parties, their nomination is their ticket. That's the way it was for libertarians before this new law, and that's the way it should be again, because the vetting goes on in the nomination process. The process may be different depending on if you're primary or if you're convention party, but it is that process that before has been sufficient vetting to make sure you don't have to do anything else to access the general election ballot. The advisory, I want to talk about the advisory a little bit. That made a bad situation worse. And even though the libertarians could see the new law coming, they did not see the advisory coming, which changed it from nominees to candidates. So that was totally out of the blue. And it also changed it in the time for compliance, because there is no time for compliance in the law itself. But the secretary just made up a time for compliance, which made it much more difficult than it would have been had there been some more lead time on that. But we think the advisory, as it says, that if the candidate didn't comply by the time of application of nominations, he was ineligible to be considered for nomination at convention. Well, that's not in the law. And that impermissibly interferes with the internal functions of a party. Because you can have multiple candidates for an office. You frequently do. You want that. That's competition. But only one's going to be the nominee. And the Libertarian Party has rules that are a little different. They have a concept called NOTA, none of the above. So that the convention delegates, if they choose, they do not have to nominate anybody. Even though you're the sole applicant, you're not assured of getting that spot on the general to the general election ballot. So it would be ridiculous and burdensome beyond belief if just everybody who wanted to apply for nomination had to comply with this rule. Now, the impact on voters should not be overlooked. Voting is a fundamental right. And Anderson talks about voters can only express their preferences by voting for people on the ballot. So anything that impairs eligibility of candidates affects voters. And that a law that falls primarily on third parties or new parties or protects the major parties from competition is on its face unconstitutional. I'm going to just talk briefly about the sovereign immunity claim. We think it's bogus. We call it a jurisdictional Hail Mary. The relief we want is, of course, to deny both appeals and to lift the stay, especially this court's stay of December 20th needs to be lifted at this point. We want to have the injunction upheld and the denial of the plea to the jurisdiction. Yes, and we did ask for sanctions for frivolous appeals, which 40 years of practice I have never done before. We want to remand this case back to the trial court so it can be enforced. And there is no provision, no justification for dismissing this case. This is just about a temporary injunction. Even if the temporary injunction does not stand, a permanent injunction might. There's no reason to dismiss the case. But there is no sovereign immunity. That only applies to money damages, does not apply to constitutional claims or ultra vires claims, which is what we said the Secretary of State's advisory was ultra vires. And it's very telling that in this federal court case, of which the Secretary is so fond, did not mention sovereign immunity, didn't raise it. The viable claim that the Secretary puts forth, the case of Patel, Supreme Court case of Patel, destroyed that argument. And so there is no viability question, and there is no immunity. Thank you.
I have one quick question. You said the state convention has not occurred yet and was postponed.
Yes, because of the coronavirus, Governor Abbott's, one of his orders, he adjusted some dates in the election cycle. And because we were shut down during April, they could not have their convention. And it is
when is the convention going to occur?
July 31st, August 1st is actually the day
Okay.
of nominations.
Okay. All right. Thank you, counsel.
Thank you.
All right, counsel, you can proceed.
You're on mute.
I apologize. Thank you. As to the jurisdictional arguments that counsel just brought up, I'm comfortable resting on our pleadings on those unless I can be helpful to the court on any of those, but I think everything that was raised is addressed in our briefs. The other thing I would like to respond to is the reliance on the Thurston case that was mentioned in the letter brief filed yesterday is completely misplaced. That case has no bearing on the actions of this court on any issue being from the Eighth Circuit, but it also has no relationship to the facts in this case. The law at issue in Thurston, under that law, no third party had ever achieved ballot access. And as counsel acknowledged, the state was still making it more demanding. It also imposed a substantial signature requirement and a deadline 425 days removed from the general election. It is simply nothing like this case. There's also no legal authority for the proposition that a filing fee, which has a petition alternative, operates as any kind of tax, not least a poll tax. And I'd also like to emphasize again that every Democrat and every Republican that is on the primary ballot has had to pay a filing fee or submit a petition. So necessarily, if they're on the general election ballot, they've complied with that requirement as well. It's still just as burdensome for the candidate who wants to seek their party's nomination. And none of them are guaranteed access to the general election ballot. So in that sense—
You do agree that your client cannot impose a requirement that is not required by the statute?
Yes, Your Honor.
Okay.
I do agree with that. And the advisory is simply coordinating the compliance with that requirement. And as the federal district court stated in Miller, and recognizing that that court does not bind this court, but I do think that case is persuasive. It held that the advisory conforms the implementation of the new section 141.041 with the already existing statutes and rules that set the same deadline. So in substance, it seems to be a claim that not that certain candidates cannot associate with their supporters, but simply that they are not being supported by enough people to allow them to complete a petition. And that doesn't amount to a constitutional injury in this context.
Are the petition requirements, remind me, because I can go through this, but you might know this off the top of your head. Are the petition requirements the same as they are for the major party candidates?
Yes, Your Honor. Both the filing fees and the petitions are the same regardless of what party the candidate is seeking the nomination of.
So it is slightly more burdensome on a minor party candidate because they don't, I mean, just by sheer numbers, there aren't as many libertarians as there are Democrats or Republicans in a particular district.
I think, though, Your Honor, that goes back to the idea that there is not a constitutional right to be a candidate. There's a constitutional right to associate with as many people want to associate with one as a candidate, but not to that candidacy in and of itself.
All right, any further questions? All right, thank you, counsel. And the case of Hughes versus Dykeman is submitted. Thank you for your argument.